Leading our bulletin this hour, amid ongoing retrieval efforts at the Stilfontein Mine Shaft in the northwest, the Gauteng High Court in Pretoria has dismissed the main bid by the Society for the Protection of Our Constitution to grant relief for the suspected Zama-Zamas underground.
Now, in a judgment on Monday, the court found, among other things, that there was no proof to show that government's response to the issue is not measured, considered and proportional. The applicant sought a final interdict after the court granted interim measures which ordered the unblocking of the mine shaft, and also that any miners that are trapped in the mine shaft shall be permitted to exit, and as well as no non-emergency personnel to enter the mine shaft. The bid by the society, which holds the primary objective to protect, uphold and promote the Constitution of the Republic of South Africa, was triggered by a statement made by Minister in the Presidency, Ntshabeni, which reportedly stated, among other things, that the miners would be smoked out and persecuted, and that no help would be sent to criminals. The applicants charged that this perceived government's stance in direct of the conflict with the fundamental rights enshrined in the Constitution, specifically the right to life. And the government entities there cited in the application were SABC as well as the DMR, however, argued for the dismissal of the application, citing that the allegations of human rights violations were in fact void of any evidence. As promised, we stay with this particular story now and speak to Canny Maphanga, SABC News Reporter, who's been tracking this one for us. Kenny, certainly this is, when you look at the fact that the court ruled urgently that, of course, there would be some relief for some, as they saw it at the time. People thought it was a done deal. And now today this matter comes. It certainly shocked quite a number of people on the ground. Let's talk about the reasons that the court gave for this particular judgment.
Well, good afternoon to you, Bongiwe, and to the viewers at home. I think today's judgment was expected based on what we've seen unfolding at the mine in the northwest. When they went to the High Court initially, it was on an urgent basis, and it was premised off of the statements made by the minister in the presidency. That is what the court had before it to give those interim measures. And then it was postponed for the main application, the main bid, which is what you're seeing a judgment for now. Now, to get final relief, you have to meet those stringent requirements for an interdict. You have to establish a clear legal right. You have to show that if this interdict is not granted, irreparable harm will be suffered. You have to show that the balance of convenience favors you, and you'll have to show that there's no other alternative other than to approach the courts. In this instance, it will have been the Gauteng High Court in Pretoria, to achieve that relief that you say is in direct consequence or risk if they don't have any of those Bill of Rights preserved. But we know that when the situation unfolded, that there was seemingly an about turn from those statements that were perceived to be a government stance, and then what we saw unfold, which were ongoing retrieval efforts, which continue as we speak right now. So essentially there's nothing further that the court can give you an order on with respect to this, because we know that the court has seen that there is evidence that there are retrieval efforts going on, and they're saying that the government's response is measured, and there's nothing that supports the serious allegation that there is allegedly human rights violations at the Stilfontein mine. So the court can't grant that final interdict, looking at the scenario as it is right now.
And, when you think about the families, because they had pinned their hopes on this particular process, hoping that at some point, because the court ruled in that manner, it could at least support their case. But there's certainly serious implications here when you think about what happens going forward. What are those?
Well, certainly, I think what the applicants were trying to do is that they were trying to clarify government's obligations in terms of the Constitution with respect to scenarios such as this, where we know the issue of illicit mining is a prominent feature in South Africa's landscape, and will be confronted with this issue for years to come until this issue is resolved. So they know that there are certain obligations created on government in order to resolve these issues. I don't think that had it not been for those statements that we would have seen that application go to the Gauteng High Court, but it's quite evident that as we speak right now, those measures are not necessary as we see the ongoing efforts by government. And of course, the court has to be very mindful not to curtail the government entities and their responsibilities, because you are effectively dealing with a alleged crime scene. You are dealing with illegality, illicit mining. So the SAPs specifically have a Section 205 constitutional mandate rather, to uphold the rule of law. So the court can't stop those operations from continuing. And then of course, with respect to the Chapter 2 Bill of Rights, as we speak right now, there was no evidence before the court when it sat for the main bid that those particular rights, those fundamental rights that are afforded to everyone, were at direct risk as they spoke before the court, because we saw that those ongoing retrieval efforts were continuing in the Stilfontein mine, and of course you are seeing these miners come to the surface.
And I suppose it also speaks to what the SAPS's provincial commissioner had to say earlier on, who was saying that we feel vindicated because we have been continuing with this. Yes, there are claims that underground, some of them are being kept against their will, but at the same time, we as the police feel vindicated that we were doing our jobs. And in fact, we were saying that from the get-go that this is what we're trying to do, to establish whether or not this case, needs to go to court, because we are viewing this as a crime scene still.
Well, we have to be accurate. I stand to be corrected, but I do remember that after the minister's statements, we didn't see an outright distancing from those statements that were said by the minister and the presidency, and therefore it was perceived as a government stance. So initially, it was taken on the backdrop of those statements. Of course, when the days passed, the circumstances change, and some may argue that the interim order did assist to some extent, because following the issuing out of that order, you did see the unblocking of that mine shaft. So it served to some degree, but it's not necessary to obtain a final interdict, or rather the applicant failed to advance to the court why it should get a final interdict when all the government entities involved are doing their respective jobs, and we are seeing the miners come to the surface.
And it's quite interesting developments, even as we saw that briefing earlier on there with the police commissioner in the Northwest, the provincial that is, as well as the MEC. So certainly interesting developments, as you say, and we'll continue then maybe to even see this retrieval operation, as they're hoping that more of the illegal miners do come up, because they're still saying that they still see a number of them who are going back underground. But Kenny, thank you so much for that update there. That's my colleague Canny Maphanga, SABC News Reporter.